Hello everyone, I'm Giri and today I'd like to welcome you all to a very special episode of SEO Explains. Today is a special video for us for a few reasons. One is that this is the first time we're shooting a video like this with all members of the team here. Of course, we're missing two main members of our team, Dr. Sudhir Krishnaswamy and Vikram Shah. But who we have here with us today is Advay Vora, Mansi Shah, Sushovan Patnaik, and Sai Spandana. So the other reason that this video is very special for us today is because this is a review of one of the busiest years that the Supreme Court has had in recent times. As the court closed for the year on 20th December, we published a list of top 10 judgments of the year. These were cases that stood out for their significant political, economic, and social impact. But we felt that just choosing 10 out of almost 1,000 judgments that the court put out this year was, well, it wasn't easy. But we also felt that some interesting and important cases were left out, and these were cases that needed to be highlighted. So we've come up with an alternative list of cases. These are cases that each of us have picked based on some of our preoccupations this year. So yeah, let's get right into it. Advay, you can please take center stage and tell us your pick for the alt list of the top 10 judgments of 2024.
So Vikram introduced my topic or my preoccupation in the newsletter as otherwise into birds and climate doom, which is kind of true because both of these elements are highlighted in this case, and it's about the Great Indian Bustard. These animals are about less than 150 in number since the last time their population was checked. And turns out that when they migrate, they go through Rajasthan and Gujarat where there are solar transmission lines. And often these poor things, because they're poor sighted, they crash into these transmission lines and get electrocuted, and sadly they die. So the court had issued an order in 2021 saying that these transmission lines have to be completely underground mandatorily so that this does not occur again. Turns out this is financially very difficult for the union government to pull off, and it's also impossible to put these kind of solar transmission lines underground because an animal might be walking by and would suffer the same fate as the bird over these transmission lines. So the Supreme Court kind of modified that order and said that they formed a committee because they found that the benefits of solar transmission lines for the climate are a lot better and are a lot good. And if you put that next to the preservation of the Great Indian Bustard, then it's a difficult choice to make. So they made a committee to decide if there can be any diverters or anything that they can put any kind of sensors so that the bird can hear it and can divert its migration path. So that is why this was my pick. It was about the Great Indian Bustard, and it was also the judgment where the Supreme Court reiterated the fundamental right against climate change. But also because I'm a biology student and this was one of my topics in school about endangered species. So yeah, that's my case. It's about the Great Indian Bustard. So with that, over to you, Sushovan.
I think my pick for my favorite judgment of the year has to be Sukanya Shanta versus Union of India. And basically, for a very long time, the prison manuals in our country, they're some of the most outdated legal documents which exist. They have a colonial tinge, and I think it was long overdue that we kind of revisit them and overhaul them. And it was also that judgment and the way in which the litigation came into being. To me, it tells a really powerful story of how collaborative activism between journalists and lawyers can be like. Because this litigation kind of starts in 2020 when Sukanya wrote an investigative story for Wire, where she pointed out that not only does caste-based discrimination exist in prisons, but that they are being perpetuated by laws, right? They're being perpetuated by state prison manuals and rules. So yeah, the Supreme Court has struck many of these problematic provisions which discriminate on the basis of caste across state prison manuals on the basis of Articles 14, 15, 17, 21, and 23. Some of the notable, I think, grounds that I can point out quickly are that the court noted that the segregation of work on the basis of caste, the segregation of barracks on the basis of caste, it did not fulfill the intelligible differentia and the reasonable nexus criteria that needs to be fulfilled for scrutiny of Article 14 to survive. Any of the objective of prison manuals has to be security and reform and correctional objectives, right? Where and just segregating on the basis of caste does not meet any of those objectives. Secondly, this entire idea that prisoners from Dalit, Bahujan, Adivasi, or DNT communities cannot be allowed to cook in prisons, or that upper caste community prisoners from upper caste communities should not be doing menial jobs, as the prison manuals often describe them. This was rooted in untouchability. So, a very important observation on Article 17 also comes from there. And another very important observation, I think, of the court was that Article 23, which prohibits forced labor, is a caste conscious provision, which is to say that the Constitution is aware of the fact that labor and caste are intertwined elements. Historically, we have had a system where menial jobs like manual scavenging has always been particularly imposed upon people from oppressed caste groups. So to say that these manuals are also violative of the forced labor prohibition in the Constitution was also important. And the court also brought to notice that even in the Model Prison Manual 2016, which is supposed to be the model document, had several problems. Like, one particular provision of the 2016 Model Prison Manual says that denotified tribe communities would be described as habitual offenders. The court has now given directions for the modification of the manual, for the updating of the state prison manuals. It has given a timeline for that. So I think in all these ways, it was very important. The only slightly problematic part of the judgment, which was that caste columns in prison registers should entirely be deleted. Um, and it was problematic because that would have impeded research on caste representation in Indian prisons. That also was corrected in former CJI Chandrachud's last working week. And the court sort of said that, basically the NCRB data collection process, which also collects caste data, will not be impacted by the judgment. And I think another big part is that the most consequential the biggest consequence of the judgment is still to play out, because the court has now started a suo motu case on discrimination in Indian prisons. So from January 2025, we will have a continuing monitoring case by the Supreme Court, where the court will be monitoring discrimination on the basis of caste, gender, disability in Indian prisons. So I think quite a landmark judgment in all of these ways. So that's my pick. Over to you, Spandana.
Thanks, Sushovan. So I did cheat a little bit because I chose like an entire jurisdiction. But for good reason, I think. Uh, Gary, I think your recent study also showed that this was the year with the highest number of suo motu cases. Suo motu cases are basically cases that the court takes up on its own volition. And these are usually cases of like public interest. And I think throughout the year, they were good examples of the use of suo motu jurisdiction this year. The RG Core case, for example, was a big one, and I felt like there was something um, very moving, and it was very necessary also for the court to step in at the time. But the judgment that stands out to me is actually a judgment in which the Supreme Court overturned the judgment of the Kolkata High Court, which concerned the rights of children. I think there's a lot to appreciate in this judgment, but I will restrict my answer to just two reasons. The first thing is the court obviously said that under the Protection of Children from Sexual Offences Act, consensual sex of a minor is not an exception. So that was a holistic sort of interpretation of the act. But while also doing this, what really stuck with me was the fact that the court came down heavily on certain personal observations made by the judge of the Kolkata High Court, in which he had basically said that teenagers, adolescents must control their sexual urges, and had made several of these unsavory comments, and the Supreme Court made it a point to say that, these kind of personal comments must be kept outside the purview of judgments. And they also upheld the right to privacy of adolescents in the country. which I thought was extremely important and relevant. So that's why this judgment stood out to me. But for the audience, if you haven't already, you should read Gauri's data study on the court's suo motu jurisdiction this year. It's the highest number of suo motu cases the court has heard since its establishment. And there's also some very interesting data points you will find. So go ahead and read that in our court data section. Over to you, Mansi.
Thank you, Spandana. So the judgment which really stood out for me this year was something which really hit close to home for me personally. It was the case of Gaurav Kumar versus Union of India. So the reason that this case really stood out for me was majorly because I'm a fresh law graduate. We can go back to the month of July when both of these things happened, me passing out as a law graduate, at the same time the judgment also coming out. So when I was going through this entire process of registering myself as an advocate with the Delhi Bar Council, I had to pay a hefty amount to sort of get myself enrolled. The enrollment fees are exorbitant. The paying hefty enrollment fees for registration with the State Bar Council is a problem a lot of law graduates face every year throughout the country. So when I was going through this process myself with the Delhi Bar Council, I was told that the authorities call these additional costs as miscellaneous or administrative costs, basically just fancy words for a sum that makes you sort of pause and think, especially if you're just somebody starting out new in a profession like this. So even though my savings came handy and I could manage it, but it sort of got me wondering, what about people who could not afford it, people who did not have a financial safety net, because they're students at the end of the day. You're waiting to enter into a profession for which you worked hard for a couple of years. But for them, this fee is not just a formality, it's more like a roadblock that they face when they are entering this profession. So for many aspiring lawyers, this cost could be the barrier. This cost could be the barrier between standing between them and their ability to start practicing law, basically. So it was the 30th of July when the Supreme Court delivered this specific judgment, and this changed the game, basically, post that. So in Gaurav Kumar versus Union of India, the court ruled that state bar councils cannot demand fees beyond what's prescribed under a particular section, which is Section 24(1) of the Advocates Act 1961. This amount that they have now prescribed is just a fraction of what I and many others have had to pay for the last many, many years. But it wasn't just about the money that really hit close to home for me. It was the fact that the court understood that these additional fees violated both the right to equality and the right to practice a profession. Basically, both these rights are guaranteed to each one of us under the Constitution. So the decision struck a chord because it's not just about young lawyers like me, it's about fairness, about removing barriers that shouldn't be existing in the first place. Over to you, Gauri.
Thanks a lot, Mansi. My case is one that my colleagues like to tease me about a little bit every now and then, but it's about the light motor vehicles license holders case. The reason they like to tease me about it is actually, on the face of it, this is a very technical case in the sense that it's about whether license holders can drive, that is, light motor vehicle license holders can drive transport vehicles which have unladen weight of less than 7,500 kilograms. And I understand why in first glance it's not clear why I would add this into the alt 5 list. But as we reported on the case a little bit and we sort of understood the issues that were coming out in court, we realized this wasn't simply a licensing issue. This wasn't some bureaucratic problem or documentation problem. What it was two big things. One is safety of people on roads, drivers, pedestrians, everyone, in the sense that many of the people that were in court argued that if the license holder didn't have the proper training to drive a transport vehicle, they wouldn't have the added sort of training about, say, resuscitation or safety guidance or first aid, things like that. And so they said it would be a safety issue, which I began to wonder. A lot of the gig workers that we have today, in whether it is in food delivery or cab services or anything, they are all light motor vehicle license holders driving transport vehicles for transport purposes. And so then the case went on to its second big issue, which was to say, okay, if we are to ask everybody to change into transport vehicles, transport licenses, then it would affect the livelihood of thousands of people today that have entered into the gig workers profession. And they would have to halt their services for some time, which may not seem like a lot, but for people who are working every day and who rely on that income, day-to-day income, it could hinder their quality of life in a very, very significant way. When the Supreme Court put out its judgment, this was a constitution bench. When the Supreme Court put out its judgment, it said that they don't, in fact, need a separate license because they hadn't really found that any data to support the idea that it was LMV holders who were driving transport vehicles that were causing safety issues. It wasn't that our accident and road safety data that we had was showing that it was specifically these kind of drivers or these kind of instances that were sort of causing trouble. So they said that we didn't have enough data, and they said that for people who spend hours and hours on the road and work hard and bring our essentials and all that stuff every day for us, this could impact their life in a significant kind of way. And I think this was the other reason I added this to our list is because this year, for the first time this year actually, the court heard the gig workers social security case as well, where gig workers are asking to be included in social security benefits. And the case has been pending for some time, and the court heard it one time at later part this year. And it just felt like while that case is pending, this one little thing, one technical validity of a card that they hold to that allows them to live their life was one win for gig workers in this country, which is why I added it to our list. And so with that, we come to the end of our video. I'd like to thank all of you for joining in and pitching in with your select cases for the year. And I'd like to thank all of you for watching. It's a pleasure for all of us to be doing this work, which is to watch and observe the Supreme Court. It's been an exciting year for sure. We've had a very busy court and an active roster of cases and retirements and appointments. So it's been a thrill reporting, and without your encouragement, we wouldn't be able to do it at all. So thank you all for watching, and look forward to seeing you in the next year.